And now here we are more than 700 days later, and victims are suing law enforcement, claiming those deaths could have been prevented if Colorado's red flag law had been invoked.
Now that allows courts to confiscate weapons from people that are considered at risk of hurting themselves or others. And the lawsuit claims that the El Paso County Board of Commissioners and the former sheriff opposed the law and ignored strong warning signs from the suspect.
By willfully refusing to enforce this law, despite overwhelming evidence of the shooter's intentions to commit a mass shooting, government officials abandoned their duty to protect the public, enabling this devastating attack.
Going in depth, El Paso County is one of 37 Colorado counties that have declared Second Amendment sanctuary status, saying they will not enforce red flag laws. This afternoon, I spoke in depth with DU law professor Ian Farrell about this lawsuit and how the law applies here.
Ian, thank you so much for joining us.
Thank you for having me on. I appreciate it.
So in the lawsuit, Club Q survivors claim the El Paso County Sheriff's Office failed to implement red flag laws in this case, and they didn't take the suspect's weapons away following an incident in 2021 where that suspect allegedly kidnapped and threatened to kill his grandmother. The grandmother at that time said that he would become the next mass shooter. Tell us how the red flag law works and why it's applicable in this case.
Sure. Well, the red flag law, which is officially called an extreme risk protection order, allows either household members or members of law enforcement to petition to have someone's access to weapons temporarily taken away, and any weapons they have temporarily taken away. And in order to do that, they must have reasonable grounds for believing that the person is a danger to themselves or others. And so in this case, there's obviously a lot of information that has come to light, including the things you mentioned that suggested that the person had access to guns, that he had indicated a willingness or desire to use them, including in a mass shooting. And so this does look like the kind of situation where the required demonstration of reasonable grounds would have fairly easily have been satisfied. One thing that the Sheriff's Department said at the time was that they didn't impose an extreme risk protection order because when he was arrested for these previous charges, there was a mandatory protection order put in place, and that also prevented him from having access to guns. However, that order automatically lapsed when those earlier charges were dismissed.
The red flag laws have been in place in Colorado for a couple of years now. Have there been any other cases where victims have then gone back in Colorado and sued law enforcement for not enforcing those laws?
I'm not aware of any, and whether there are such earlier cases will be relevant to this case. There are two things that the plaintiff has to prove. Firstly, they have to demonstrate that there was a violation of their constitutional rights. And secondly, they have to show that qualified immunity does not apply. And the idea with qualified immunity is that even if a government official violates someone's rights, you can't claim damages against them unless you can show that a reasonable person in that position would have recognized that their conduct, or in this case, their failure to act, violated someone's rights. And that historically has been very, very hard to do in a lot of situations, and essentially requires the plaintiff to show a prior example where a government official was held liable under similar circumstances. So that will be one of the major hurdles for the plaintiffs to overcome in this case.
Ian Farrell for us, thank you so much. We appreciate your insight into this.